Alright, so I go through the hassle of writing a writ. That's 25 pages, which is the maximum allowed before you have to write a request for more pages. And I got nowhere to send this. Oh, that 25 pages doesn't include this cover letter. So actually you kind of get 26 pages. But I mean, that means you have to do this cover letter here. But I took a fair amount of time putting this all together, putting my case together. You have to put, well, I mean, you could just type into ChatGPT and ask them what all you need for writing a writ. Okay, it takes a lot of time, especially getting these pages right. You do that at the end, but I thought the end was a few iterations before, so I had to do this all over again a few times, counting the pages and figuring out. But I mean, that's not too bad. You could just, once you get into the swing of things, you can go to Control Find. This thing seems to be in the way. I guess I can't do that. Okay. Yeah, you do like a kind of Control Find and find it. But yeah, they say you need all this stuff, so everything that's involved with the writs I put together. Statement of jurisdiction is like mandatory for everyone. This honorable court has jurisdiction over this matter pursuant to Article 5, Section 10 of Louisiana Constitution, relevant Louisiana statutes and court rules. And then here I start talking about the background of my case. Following a remand from the appellate court, the state case remains active in the lower court, and the recent rulings are now subject to review. The rulings in question arise from proceedings in Natchitoches City Court on October 18th, which resulted in the denial of key motions and procedural orders affecting the defendant, Mr. Hines. This court, as part of the Louisiana Third Circuit Court of Appeal, retains authority to review procedural and substantive decisions made by the lower courts within its jurisdiction. Issue statements. Denial of motion for continuance and remote participation. Did the trial court err in denying Mr. Hines' motion for continuance of the trial date and request for a Zoom hearing, thereby violating the defendant's right to participate in court proceedings? Failure to appoint counsel. Did the trial court err in failing to address the defendant's request for court-appointed counsel after his previous legal representation was terminated in violation of the defendant's Sixth Amendment right to counsel? Denial of motion to recuse prosecutor. Did the trial court err in denying the defendant's motion to recuse the prosecutor without a substantive review of potential conflicts or bias, thereby denying the defendant a fair trial? Denial of motion to quash. And that's what I was charged with. Did the trial court violate the defendant's rights by refusing to consider the constitutional arguments raised in Mr. Hines' motion to quash the charge, particularly concerning Fourth Amendment protections against unreasonable searches and seizures? Improper issuance of bench warrant. Did the trial court err in issuing a bench warrant for the defendant's failure to appear, despite Mr. Hines' attempts to participate remotely, and where no such warrant was issued during the period which he was under the jurisdiction of the Third Circuit Court of Appeal and the Louisiana Supreme Court? Improper discovery order and violation of Fourth Amendment rights. Did the trial court err in ordering the defendant to provide evidence to the prosecutor, violating the defendant's Fourth Amendment right against unreasonable searches and seizures? Due process violations and denial of appeal rights. Has the trial court's improper handling of records, misrepresentation of motion dates, and failure to accommodate the defendant's participation via Zoom violated his constitutional right to the due process? Improper change from hearing to status conference. Did the trial court err in converting the trial scheduled hearing to a status conference and proceeding to rule on substantive motions, thereby violating Mr. Hines' due process rights and right to be present, as the defendant was not given the opportunity to participate or be present remotely as requested? Alright, and then those are the questions. The assignment of error is just making statements that yes, those questions are not. It's just turn them into make them into statements. And it's all pretty much the same, same information. So let's just skip over that. I'll just be reading the same stuff. Statement of the case. This is like background. On January 31st, 2023, the Court of Appeal, 3rd Circuit, remanded this case to the Natchitoches City Court for further proceedings. The case remains active and is currently before the lower court following the remand. On October 18, 2024, the Natchitoches City Court under Judge Brian Barber denied several motions submitted by Mr. Hines, including a motion for continuance, motion to recuse the prosecutor, and a motion to quash on constitutional grounds. Additionally, the court issued a bench warrant for Mr. Hines' arrest due to his inability to appear in person despite his request for either a continuance or to attend the hearing via Zoom, as either option would have sufficed. Mr. Hines has demonstrated consistent and cooperative participation in the appellate processes of the 3rd Circuit Court of Appeal and the Louisiana Supreme Court, where he conducted himself responsibly and honorably. Prior to ruling on those substantive motions, Judge Barber unilaterally converted the scheduled hearing into a status conference. Status conferences in Louisiana are typically used for procedural management, such as scheduling or addressing preliminary matters, not for ruling on substantive legal motions that impact the outcome of the case. By reclassifying the proceeding, the court circumvented Mr. Hines' right to be present and participate in the hearing, a right protected under both Louisiana law and the United States Constitution. This action was especially prejudicial because the court continued to rule on substantive motions in Mr. Hines' absence despite his previous compliance with appellate courts when attending hearings remotely. There is concern that Judge Barber may be following a similar pattern as that observed under Judge Ousley, whose rulings resulted in Mr. Hines' immediate incarceration without an opportunity to file an appeal. During his incarceration, Mr. Hines was unable to access essential resources such as legal counsel, writing materials, or information needed to navigate the appeal process, while volunteers outside the jail took it upon themselves to find a lawyer who initiated the writ process on his behalf. Mr. Hines was unable to participate or assist in any way in the effort to secure legal representation, accepting the circumstances as they were presented. This lack of direct involvement, combined with the barriers within the jail, effectively prevented him from actively exercising his right to appeal and pursuing further legal recourse, undermining the procedural fairness of the judicial process. Additionally, the court ordered Mr. Hines to provide evidence to the prosecutor, which the defendant argues violates his Fourth Amendment rights. This directive improperly shifts the burden onto the defendant to assist in building the prosecution's case, contravening established constitutional principles that protect against self-incrimination. Mr. Hines maintains that as a defendant he is under no obligation to produce evidence that could potentially incriminate him, and such an order reflects a fundamental misapplication of the law. Summary of arguments. That's a new section here. The trial court unjustly denied Mr. Hines' motion for continuance and his request to attend remotely, limiting his ability to defend himself and violating due process. It says, especially given his previous approval for remote participation. Following his attorney's termination, the court failed to either appoint new counsel or conduct a FREDA hearing to confirm if he wished to represent himself, infringing on his right to be representation. Procedural fairness was further compromised by the court's favoritism towards prosecution motions over Mr. Hines', which included improperly denying his motion to recuse the prosecutor without a required review. Mr. Hines' motion to quash challenges the law as an unconstitutional infringement on Fourth Amendment protections due to vague language that risks arbitrary enforcement. The court's issuance of a bench warrant, despite Mr. Hines' stated inability in person, disregarded due process standard, keeping errors and denial of access to hearing transcripts based on indigency, undermined his defense, and violated equal protection Lastly, an order compelling Mr. Hines to produce evidence infringes upon his Fifth Amendment rights by improperly shifting the burden of proof and risk self-incrimination. Arguments. Denial of motion for continuance, Zoom hearing, and improper conversion to status conference. On September 25th, 2024, Mr. Hines filed a motion for continuance and requested to participate via Zoom. The trial court's lack of substantive response denied him the opportunity to defend himself, violating his due process rights. Previously, Mr. Hines had been allowed remote participation before the Third Circuit Court of Appeal and Louisiana Supreme Court without issues, and he was permitted to leave the state in May 2022 with remote access in mind. In State v. Stephenson, the Louisiana Supreme Court found a denial of continuance to be an abuse of discretion when it impeded a defendant's right to effectively assistance and a fair trial. Similarly, in State v. Jones, the court held that such denials were an abuse when they limit the defendant's chance to prepare a defense. The trial court's refusal to allow remote participation and denial of continuance here deprived Mr. Hines of a fair trial, violating Louisiana Code of Criminal Procedure Article 831 and the 14th Amendment. On October 18th, the court further converted the hearing into a status conference, which is intended only for procedural matters. By addressing substantive motions at this conference, the court deprived Mr. Hines of meaningful participation, violating due process. Louisiana Code of Criminal Procedure 833 supports remote attendance when physical presence is impractical, highlighting the court's abuse of a discretion and infringement on Mr. Hines' rights. Failure to appoint counsel and conduct a Ferretta hearing. The Sixth Amendment and Louisiana Constitution, Article 1, Section 13, guarantee the right to counsel at all stages of criminal proceedings. After Mr. Hines' attorney was terminated on September 13, 2024, he promptly requested court-appointed counsel. The court's failure to respond to this request violated the constitutional rights as affirmed in Gideon v. Wainwright and reinforced by the Louisiana Constitution. The Natchitoches City Court proceeded without counsel for Mr. Hines, defying the Third Circuit's ruling in Natchitoches v. Hines, which upheld his right to representation. By failing to appoint counsel or grant a continuance, the court disregarded constitutional mandates. If the court assumed Mr. Hines intended to represent himself, it was required to conduct a Ferretta hearing to ensure a valid waiver of counsel per Ferretta v. California. Without this hearing, any waiver is invalid, constituting reversible error. Cases like State v. Daigle and State v. Stephenson underscore the need for adequate time and representation. The court's inaction violates procedural safeguards, undermining Mr. Hines' due process rights under the 14th Amendment and Louisiana Constitution. Improper handling of motions. The court showed procedural inconsistency by granting the prosecution's motion to convert the hearing to a status conference, while leaving Mr. Hines' continuance motion unaddressed until it was denied at the hearing. Addressing Mr. Hines' motions after converting the hearing introduced procedural irregularity and raised questions about impartiality. In State v. Johnson, the appellate court held that prioritizing prosecution motions over a defendant's can compromise fair trial rights. Here, the court's actions deprived Mr. Hines of a fair opportunity to defend himself, violating procedural fairness and due process. Denial of motion to recuse prosecutor. The trial court improperly denied Mr. Hines' motion to recuse Prosecutor Clay Benjamin without adequate review, violating Louisiana Code of Criminal Procedure, Article 680. This failure to investigate potential conflicts compromised Mr. Hines' right to a fair trial. In State v. Bork, the Louisiana Supreme Court held that a hearing is required to investigate prosecutorial bias under Article 680. The trial court's denial of Mr. Hines' motion without such review mirrors the procedural error in Bork and infringes on his rights. Motion to quash. Mr. Hines' motion to quash challenges the charging statute on constitutional grounds under the Fourth Amendment, which protects against unreasonable searches and seizures. The statute's vague language lacks clear standard, allowing arbitrary enforcement by law enforcement officers. In Terry v. Ohio, the U.S. Supreme Court required that any stop and frisk be based on reasonable suspicion supported by specific and articulable facts. The charge allows arrest for resisting an officer without sufficiently fining prohibited conduct or requiring reasonable suspicion, enabling stops and arrests without adequate safeguards. In State v. Moreno, the Louisiana Supreme Court struck down an overbroad statute that infringed upon constitutional rights. Similarly, the charge is unconstitutionally vague and infringes on Fourth Amendment protections. The trial court's refusal to hear these constitutional arguments deprived Mr. Hines of due process under the 14th Amendment. Issuance of bench warrant. The bench warrant issued for Mr. Hines' alleged failure to appear on October 18th was disproportionate. Mr. Hines communicated his inability to attend in person and requested remote participation. Previously, he had participated remotely without issue. In State v. Batiste, the court held that issuing a bench warrant for failure to appear is improper when the absence is justified or less severe remedies are appropriate. The trial court's action in issuing a warrant without considering Mr. Hines' reasons mirrors the due process violation identified in Batiste. The Louisiana Code of Criminal Procedure, Article 833, supports remote participation, and the court's refusal to allow it reflects a due process violation under state and federal law. Record-keeping errors and barriers to accessing hearing transcripts. The court's mishandling of motion dates and reliance on inaccurate records prejudiced Mr. Hines' defense, violating his due process rights under the 14th Amendment and Louisiana Constitution Article 1, Section 2. For example, Judge Barber cited a non-existent motion date, April 25th, 2023, illustrating procedural errors. In State v. Jones, the Supreme Court recognized that indigent defendants are entitled to free transcripts when necessary for an appeal or defense. Denying access due to inability to pay violates equal protection and due process rights. Imposing a financial burden on Mr. Hines for accessing hearing transcripts despite his indigent status is unconstitutional. Improper discovery order in violation of Fifth Amendment rights. The trial court's order requiring Mr. Hines to provide evidence to the prosecution violates his Fifth Amendment rights. As a defendant, he is not obligated to produce evidence that may incriminate him, and this order shifts the burden of proof contradicting constitutional protections. In State v. Dorsey, the court held that compelling a defendant to produce evidence that may be self-incriminating violates the Fifth Amendment. The trial court's order in Mr. Hines' case paralleled the constitutional infringements identified in Dorsey. Conclusion: the trial court's actions have significantly infringed upon Mr. Hines' right to due process, counsel, and a fair trial protected by the 6th and 14th Amendment of the U.S. Constitution and Louisiana law. The denial of Mr. Hines' motion of continuance and remote participation limited his ability to defend himself. The failure to appoint counsel or conduct a FREDA hearing after his attorney's termination disregarded vital protections for his right to representation. Procedural inconsistencies, including the denial of his motion to recuse the prosecutor and the refusal to hear his motion to quash, further compromised the fairness of the proceedings. The issuance of a bench warrant, record-keeping errors, restricted access to transcripts, and an improper discovery order that violated his Fifth Amendment rights further obstructed his defense and infringed upon his constitutional protections. Prayer for relief. For the reasons stated above, appellants respectfully request that this honorable court reverse the trial court's denial of the motion for continuance and refusal to allow remote participation recognizing the violation of due process rights. Vacate all actions by the trial courts following improper denial of counsel, including rulings on motions and the issuance of a bench warrant. Remand the case with instructions to appoint competent counsel or conduct a FREDA hearing if Mr. Hines opts for self-representation. Rehear the motion to recuse the prosecutor per Louisiana Code of Criminal Procedure, Article 680. Allow Mr. Hines to present his motion to quash the charge and address related constitutional issues. Correct record-keeping errors and ensure accurate documentation. Provide necessary transcripts and legal materials without imposing undue costs on Mr. Hines, recognizing his indigent status. Avoid discovery orders that infringe on his Fifth Amendment rights. Grant any other relief deemed just and proper to protect the appellant's constitutional rights and the integrity of the judicial process. And that's what I sent, or I tried to send. Yeah, there's verification. But it's not been accepted when I e-filed it. I paid $50 to e-file this, and they say it's not accepted because there's no paper copies or original copies. So that $50 goes to waste. If you think that you can just simply pay $50 to e-file this to the Third Circuit Court of Appeals, you'll be mistaken, because they're going to argue that you need to file a paper copy. So the e-filing system is a bit of a sham, and I'm asking for a refund. So yeah, I can't seem to stop this. Oh, no, that's not it. I'm trying to. Okay.